You've fallen in love with your own case, your medical malpractice case, because you believe you have the strongest of strongest cases and there's no possible way you could ever lose your case. Let me tell you why falling in love with your case is not only dangerous for you, but in all likelihood is going to force your attorney to try your case. You want to know what this is about? Come join me on this walk through the neighborhood as I share with you exactly what I'm talking about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. All right, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. Your doctor denies all of your allegations, and plus he says you, the patient, caused and contributed to your own injuries. And now you are furious, you are outraged, but you know in your heart of hearts that your doctor was careless. You know that his carelessness was so outrageous to have caused all these significant and permanent injuries. And now every single day you go to sleep with the thought that you know you have a great case. Every single day you wake up knowing that you have a fantastic case. And you know in your heart of hearts that when it comes time to negotiate your case, you are never going to accept a dime. You're never going to accept anything the defense offers. Why? Because in your mind, there is no possible way they could ever compensate you appropriately through a settlement. So you make it well known to your attorney that under no circumstance will you ever negotiate with the defense, and even if they do decide to negotiate, there is no chance in hell you will ever accept whatever it is they offer. What does that mean? It means you're pressuring your attorney and you're forcing him to actually go to trial. Now, why would that happen? I'll tell you why it would happen. There may come a time during the course of your lawsuit where the defense makes an offer, a substantial settlement offer, and now I relay that information to you. I have an obligation to discuss with you the risks associated with rejecting that offer, the risks associated with accepting that offer, as well as the alternatives. What are your choices? What are your options? Now, you as the injured patient have every opportunity to either accept or reject that offer or make a counteroffer. So now, based upon the title of this video, you are so in love with your case, you believe that there's no possible way you could ever lose your case. So you immediately reject the defense's offer and tell me under no circumstance will I negotiate. You tell the defense that they don't care what they offer. They could offer $25 million. There's no way you're going to go ahead and settle this case before trial. Instead, you want a jury to go ahead and put a value on your injuries. One of the things I want to share with you, especially in this video, is that the choice to go to trial can be very risky. You may think, based upon the strength of your case, the strength of your convictions, that there's no possible way you can lose this case. Well, let me share something with you that may open your eyes. In a case like this, any case that goes to a trial, that goes to a jury, anything can happen. It doesn't matter how great your case is, it doesn't matter how great your experts are, anything can happen. And that means you could lose your case. That means you might win on liability, where we could show that the doctor was careless, but we might not be able to show that his carelessness caused you injury. We might be able to show that, yes, the doctor was careless, and yes, the doctor's carelessness was a cause of your injury, but then there is a possibility that the jury could come back and give you much less than what you are asking for, much less than what has originally been offered by the defense. In that instance, you are going to be extremely disappointed. Why? Because when you go to a jury verdict, anything can happen. It doesn't matter how great of case you have. It doesn't matter what great experts you have. It doesn't matter how much you love your case or how much you believe in your case or how much your attorney or your experts believe in your case. The fact is, the jury can turn around for many different reasons and force you out of court without getting a single dime. And that's something you don't want to be left with. So you have to weigh very carefully any time that the defense makes an offer, especially a substantial settlement offer. Your attorney is going to give you his legal opinion about whether or not he thinks it's appropriate to accept this particular offer, or whether it's appropriate to make a counteroffer or another strategy. There may be other settlement strategies he discusses with you. So when I say don't fall in love with your own case, don't get the opinion, don't get the feeling that you are invincible even though the facts are on your side, even though all the experts align with you and confirm you have a valid basis for a case. The last thing you want to happen is deciding to go after what's behind door number 2, which is what's behind the jury verdict, and now not knowing what the answer is ultimately going to be. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but are still thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.